This is a presentation of Speaking of Justice, an affiliate of the Legal Broadcast Network. I'm Scott Drake. The landscape of design patent law changed fundamentally following a federal appeals court ruling this week that sets aside the decades-long use of the point of novelty test in assessing design patent infringement. The U.S. Court of Appeals for the Federal Circuit ruled unanimously Monday that design patent infringement analysis must be rooted in the long-established ordinary observer test, essentially whether the accused design embodies the appearance of the patented design. Now, my guest is Tracy Jean Durkin, a partner at Sterne, Kessler, Goldstein and Fox, who represented the Intellectual Property Owners Association in briefs in the litigation. Welcome, Tracy.
Thank you. It's nice to be here.
Well, congratulations. This is an interesting ruling. Talk about the case itself. Give us some background.
Well, the case was a typical patent infringement case. It came out of the District Court of Texas, and it involved a patent on a nail file. And in this particular case, it was just a nice vehicle that the Federal Circuit was able to use in order to reevaluate the test for design patent infringement, which had really devolved over the years into a detailed picking apart and analysis of designs to the point where a very detailed analysis of the drawings of the design patents was being done by the district courts. The beauty of a design patent is that it rests in the drawings. There's very little verbal description in the patent itself when it issues from the Patent Office. In fact, the Patent Office discourages over-verbalization of the patents. But yet when these patents were getting to court, the district courts were finding themselves reducing them to a verbal description. And as you and I both know, we each could look at something, sit down and describe it in writing, and we would come out with two very different descriptions.
Right. Talk about the point of novelty test, which has been used in the past, and now, I guess now that we're moving to something else again, this gives a little more protection, right?
Yeah, this certainly opens up the scope of design patents. The point of novelty was something that had been developed in the case law in the last 25 years, and the problem with that test is that it required, the way the courts were applying it, it required the patentee to look at his own design patent and then come up with an explanation of basically why it had been issued by the Patent Office. That was a step that the Patent Office doesn't even require in order to get the patent. And so what was happening in the litigation is patentees would have to reduce to writing some description of why their design was patentable, what made it novel, and then, of course, the defendant would use that description as a way to attack the patent. They would go out and do a patent search. They would come up with a whole bunch of prior patent references that showed individual features, and then they would piece those features together and say, aha, your patent isn't valid. Right. And so the real problem with this is that it had turned into a patentee having to defend the validity of their patent when really they were just, their burden was to make out a case for infringement. And so this case is wonderful because it actually properly places the burden of bringing any prior art into the case on the defendant rather than on the patent holder.
And I guess in the past there was always a lot of confusion as to whether the point of novelty test was a separate and distinct test, right?
Yes, the original Supreme Court case that considered design patent infringement over 100 years ago never talked about a point of novelty. And the court actually does a nice job of giving the historical case law that led up to a Federal Circuit case in the 1980s that was the first to really describe the point of novelty as a separate test, and everything sort of took off from there. And what the court has done today is it said prior art can and should be considered in the analysis, but it's not a separate test, that the prior art informs the scope of the patent in the infringement test.
So how does this affect the future cases, and are you working on some other cases now?
Well, yes, I'm pretty active in this area, so this will affect a lot of the cases that I'm working on now. This should make it easier for a finding of infringement. It's a little ironic that in this particular case the court still concluded there was no infringement. But I think a lot of that had to do with the way the case had been prepared for the appeal. Neither party objected to the verbalization of the design in the lower court stage, and so the Federal Circuit had no reason to overrule that verbalization. And so I hesitate to think that the decision probably would have been different if it had been decided after the Egyptian Goddess came out. But I do think that it certainly is a case that will strengthen the value and the applicability of design patents, especially in the consumer product area where knockoffs are such a problem.
Yeah, now when somebody wants to do a knockoff, it's a little bit more difficult.
I think so, because there's great language in the case that talks about the design infringement being something that's substantially similar or a colorable imitation thereof. And it also reminds us of the language from the Litton case that discusses how minor differences between the accused design and the patent are not the focus, that you should be focusing on what's similar, not what's different.
Well, congratulations. It's a very interesting case and a very interesting area of practice. My guest is Tracy Jean Durkin. She's a partner at Sterne, Kessler, Goldstein and Fox, which represented the Intellectual Property Owners Association in the briefs and the litigation in this case. I appreciate your time, Tracy.
Glad to be here. Thank you.
This is Scott Drake, and you're watching the Legal Broadcast Network.